but I still be in my purse all of it. Judge James is asking if you consider the council thing. Sure.
After I jokingly said, it's your last day, you could ask that question.
Yeah, because.
She goes, James wants to.
And you're just, shy.
Everybody just know your mic is on in the courtroom, so you're being heard by everyone.
On the courtroom and counsel, I'll be with you in just a moment. I'm logging into my system so that I can actually see everyone. Thank you. Just thinking really hard. Good morning, everyone. We are going to go ahead and get started. Sorry, we're a little bit delayed. Just want to let you know that I do also have some associate or interns with me this summer, and so just always ask that you show them some good lawyering. I've got one who is actually just graduated from high school and is planning to head off to Georgia State undergrad. So she's got a little bit longer of a trip, but nonetheless headed to law school, she thinks. And then I've got 3 rising second-year law students that are observing the proceedings today. So thank you all for letting them learn from y'all. Okay, so I have first position is Boy Wonder versus Brickcell Investment Group. And I am aware, I think Ms. Teasley told me that she might be vocally challenged today for our conference, but I see that I have Mr. Mzikele, and who else do I have here on behalf of Brickcell and the third-party defendants? Mr. Mzikele, were we expecting anyone?
Yes, and I did see counsel here for a second. I don't know. I thought I saw counsel for the defendants, but
okay. Well, I'm going to keep calling the calendar then, and then I will circle back around and see who joins us, Mr. Mzikele. Okay.
okay.
Mr. Freehoff, can you check and see with Mr. I think Yaklin is who we've had before?
Sure, I'll check that out, Judge.
Thank you.
Judge, to be clear, do you want me to see if he's opened the notice, or do you want me to contact him directly immediately?
Right now, just make sure that he's opened the notice.
All right.
Thank you. Baker versus Fulton County Board of Assessors, who I have here on behalf of Baker. So I see is it Mr. or Ms.? I'm not sure, Baker. And who do I have here on behalf of the Board of Assessors?
Hello, my name is Fletcher Lagarde. I represent Fulton County Attorney's Office. I represent the Board of Assessors.
Thank you, Mr. Lagarde. As I said, I do, is it Mr. or Ms. Baker?
It's Miss Baker.
Ms. Baker, thank you. Okay. So the purpose of today's hearing, first of all, I'm just sort of making sure everybody's here, and then I'll go into some more detail with each of you. But basically, the purpose of today's hearing is just to figure out what cases are still on my calendar, who still needs to have a trial, that sort of thing. So right now, I'm just making sure that I have the parties all here, and then I'll come back and call on you in a moment to talk a little bit more about the substance of your case and how long it will take to try and that sort of thing. So Ms. Baker and Mr. Lagarde, y'all can stand down, although I think Mr. Lagarde, I'm still, you've got a number of cases maybe on this calendar.
Yes.
Rainbow Trust versus the Fulton County Board of Assessors.
Mr. Mark Thompson should be here. He represents the plaintiff.
Mr. Thompson, are you there?
I don't see him, Judge.
I see him. He just doesn't seem to be able to hear me.
And Your Honor, Brad Bowman for Fulton County as well as Mr. Lagarde on this one as well.
And as soon as we can get Mr. Thompson connected, I'm aware that y'all had asked for an extension. It's just that I wasn't quite clear on what it was. And then I asked a question about mediation that I didn't get an answer to. So I figured it was easier to just have y'all come and tell me. If y'all are in touch with Mr. Thompson, it seems like he's having an audio issue. And my experience is the only thing he can do is probably log out and log back in again. But if one of y'all can communicate that to him, I would appreciate it.
Can do. And Your Honor, I would just briefly add, we think we have this resolved and we're working on some paperwork to get it done. Just need one piece of confirmation from the assessor's office, but we believe we have the case resolved.
Even better. And I appreciate that, Mr. Bowman. I just would very much like to have
And I will let Mr. Thompson know. Yes, ma'am.
Mr. Thompson be able to participate. Thank you.
Judge, can I jump in for a second? Sorry. I just wanted to let you know that I show that Mr. Yacklin did in fact open the notice on June 23rd. So would you like me to reach out to him?
Judge, that's actually, I'm Steve Yacklin's associate. I was having some kind of technical difficulty and I did not hear when you guys called me, but I was sitting right here. So I apologize for that.
Computer, but I couldn't quite place. Is the audio okay? Are y'all able to hear me?
Yeah, it was my laptop that was making the mistake.
Mr. Thompson seems to be having the same issue. So I'm going to circle back to that one now that we've figured out who we have, and then I'll be back in just a moment.
Thank you, Judge.
To that one. Daphne Edgewood Properties versus the Fulton County Board of Assessors. Do I have anyone here on behalf of the Daphne Edgewood Properties?
Harry Jackson for Daphne Edgewood, Your Honor.
Hi, Mr. Jackson. And Mr. Lagarde, is that you or Mr. Bowman?
It'll be Mr. Lagarde. It'll be me. So.
All right. And okay, and I'm going to come back to that one in just a few minutes. And then the Tiffany Brown, Brent Savage, Legal Funding Group versus Tribute. Mr. Freehoff, is that the one that was supposed to be at 10 or is that the TRO at 10?
No, the Tiffany Brown matter, I believe, is scheduled for 9 o'clock.
Okay, just making sure. Legal Funding versus Tribute Contracting, Tiffany Brown et al. And Alcidae Honore. Who do I have here on behalf of the plaintiff Legal Funding Group?
If you can hear me coming through, it's Matthew Bradley.
Yeah, I can hear you just fine. Go ahead.
Yeah, Matthew Bradley here on behalf of Plaintiff Legal Funding Group.
Okay. And who do I have here on behalf of the, I think I've generally referred to them in other pleadings, orders, et cetera, as the Tiffany Brown defendants?
Your Honor, I wouldn't think there would be anybody here for Miss Brown. I am Joe Wiesman. I represent the Honore defendants. That's Alcide Honore and Honore Law LLC. Just based on prior precedent of this case, I think Matthew Bradley and I will be the only ones on this call, but she may join or there may be other attorneys, but that's just the way it's gone.
And I may be able to get y'all out of here pretty quickly. I mean, the reason that I set it for a hearing is because Ms. Brown has continued to file matters, but most of them are subject to being dismissed, which are, denied, which I have done. But most recently, she had filed something regarding her entitlement to participate in discovery. And so I don't know if you, but the most recent, I think y'all filed a response to it. It was a motion to open default, which I'm getting ready to issue a ruling on. There was a response that y'all filed. But part of that motion requested the ability to participate in discovery. And so that was actually the conversation I wanted to have with the parties regarding any role that she is entitled to have or might have in discovery. And so that's actually why I wanted to have the conversation today. So if you guys will wait, I'm going to finish calling my calendar and come back to you in just a few minutes. Okay.
Great. Thanks, Judge.
Yes, Your Honor.
And okay. So let me circle back to Mr. Pugh, Mr. Nzikele, and Ms. Teasley. Who do I, Ms. Teasley, refresh my memory, you represent the third-party defendants? I know you're muted. If I'm right, you can nod. I actually can't hear you. Even
Judge, and I can kind of shed some light on this. I've been emailing with Miss Teasley. We are trying to conduct some limited discovery, so we've been talking. She has laryngitis.
She communicated to me. I was letting her know that if she had made any sound at all, I didn't know she or not. Because she did communicate that she was verbally challenged today. So
okay, sorry then. I didn't mean to jump in.
Here's the issue. Where is this case, right? We were ready to go to trial. I understand there was late service and addition of these third-party defendants. There's been some effort to engage in limited discovery, but the case is set for trial, and it's been set for trial multiple times. And I'm trying to figure out, is the case ready to go to trial? And if it's not, why not? And if it's not, then when will it be?
And I can kind of shed some light on this, Judge. So the case was kind of in limbo for a while we were figuring out service. We do have one party that's in default. Admittedly, we did delay a little bit of our discovery, until the Boy Wonders motion for reconsideration was heard. That was granted on June 12th.
Mm-hmm.
I think Cool Runnings Electric, which is Miss Teasley's client, they filed their answer, and I'm pulling it up right now, but it was after the January order for us to, basically in January, you entered an order, understandably, for us to figure out service or just move the case along, and we figured it out. And so they filed an answer, relatively recently, and I think we're not even halfway into that 6-month period, I don't believe. I think talking with Miss Teasley, my clients are available for depositions most of July and most of August as well. We do plan to reach out to Mr. Nzikele to see if there's a way that we can depose Craig Johnson as well during that time. But we think that we'll have all of our discovery done through August at the latest. I've got written discovery prepared that Mr. Yacklin's reviewing that we're sending over today, very minimal, just to get a grasp on, the facts of the case before we feel confident trying it. Given the addition of that new party and the fact that, Mr. Johnson was added back into the case just about 20 days ago, Judge, but we are working to move it along. I think that given just another, month and a half to work out some discovery issues, we should have all of that finished by the end of August, or I wouldn't be surprised if we had it done earlier, Judge.
Okay. Mr. Nzikele, what are your thoughts, sir?
I have no different thoughts from counsel. Yeah, I think for the most part, I think a lot of the heavy lifting and discovery is done. I do think that there is some because of the added parties and things that have occurred, I think that there needs to be kind of some finishing touches. So for the most part, I concur with counsel.
Okay, and Ms. Teasley, you're nodding, so I'm gonna say that means you're generally agreeing with what they're outlining. Listen, generally speaking, I let lawyers put their cases together, and I know all evidence to the contrary that I'm micromanaging you guys. I don't typically do it. The issue is, Mr. Thompson, Mr. Thompson, I can hear you, but you're not muted. But counsel, in the Boy Wonder case, again, I promise I generally try not to micromanage, but this is a case, to my way of thinking, that while the lawyers have done an excellent job of making it complicated by adding parties and having multiple issues related to service, et cetera, at the end of the day, this is a refusal to pay for certain contracting work that was, allegedly provided by Boy Wonder. And I don't even think the value of that claimed work is more than 50 grand. And I trust that you lawyers have invested a great deal of time that probably at this point wildly exceeds the amount that was allegedly, that was asserted as being at issue in the complaint. And so, my point is really just, it sounds like now where, I think there was there have been so many procedural hiccups. This case was filed more than 2 years ago. And I guess now it seems like the parties are closer to being on the same track and that maybe you can actually wrap it up. It's just one of those cases that's just gone on for way longer than it really should have. It also procedurally, because of the various dismissals, and then there was a dismissal that the court reconsidered, there is not actually an operative scheduling order of any kind. And so I think what would be helpful is if the parties would take one of the scheduling orders that's been entered in this case. If the parties are intending, as Mr. Pugh outlined, to engage in some limited discovery at least through August, then on this type of case, I would expect there to be cross motions for summary judgment likely. And so there needs to be a dispositive motion deadline. And there needs to be a clear trial, week deadline that we won't move again. And so what I'd like to ask the parties is if y'all could get together and submit an agreed order that will accomplish a couple of things. One, it would be helpful. Granted, I could spend an hour going through all the dismissals and figure out which parties are still standing. But given you three fine folks, if y'all could make clear which parties are still in it, and planning to be involved in the case to discovery and present some sort of proposed scheduling order using the form that I typically have. I think we've entered a few in this case. And if y'all could do that, I know it's a holiday weekend, so maybe by the end of next week, that would be helpful. And then we will all have a clear roadmap. Just understand that I normally say absent extraordinary circumstances, but in this case, I'm not even sure extraordinary circumstances would do it. This case is not getting moved again, right? If y'all give me a deadline that says we're going to be conducting discovery and it will end in the August 30th or whatever, you should expect it will end and that the party should not ask me for additional time. This case is way older than it should be for what it is. So anyway, that's just my little vent today. Does anybody need anything else from me, Mr. Mzikawa, Mr. Pugh, or Ms. Teasley?
I agree with you, Judge. One more thing. There is a party, Marlin's General Plumbing, that's in default. If that's something that the court wants us to handle around the same time as trial, that's fine. We did file a motion for default after we were able to add them back into the case. So the motion was filed on April 11th, and they are an irreversible default. So if we, that might be something we can reach out to the court about or put something in the scheduling order to be a deadline on, but I don't want to put a deadline for the court to hear a matter. So I was just wondering what you thought about that.
Mr. Pugh?
Sorry, Judge.
Are the damages liquidated?
They're not.
They are going to be mostly unliquidated.
Okay. So, so to the extent that you wish to, there's a motion for default, we will take a look at it. I suspect that given that the damages are unliquidated and that we're continuing to engage in ongoing discovery regarding what is the nature of the damages and how to apportion them amongst the parties, it may be that what you get is not a default judgment, but an order of default, indicating that that party has not filed a timely answer and therefore is in default, and that the only thing limiting the court's ability to enter a final default judgment will be that I'll hold off on doing so until damages are proven. Now, if you'd like to have a hearing and do it in the time, you can. But if it's going to be involved, then it would be one thing. It would be something that I would wait and enter judgment at such time as the parties have engaged in whatever final thing they're going to do.
That sounds great. So that we'll put a I'll include it in an email when we would be ready, and then I'll let the court put a date on that. So I appreciate it, Judge.
Okay, excellent. Mr. Imzikawa, anything else you need?
No, Your Honor. Thank you.
Ms. Teasley, anything else? Okay, well, I hope you get your voice back soon. I hope everybody has a good holiday weekend. Y'all are free to go.
Thank you.
Thank you. Okay, Ms. Baker and Mr. Lugar.
Okay, how are you doing, Judge? So when Ms. Baker filed her appeal with the Board of Assessors, she checked for arbitration.
Okay.
So that kind of limits us right there. We would prefer, or at least the office of the attorney's office would prefer, at least a mediation for us to try to work this out without necessarily going straight to arbitration or court. It all depends on Mrs. Baker and how she feels about that.
Okay. I appreciate that, Mr. Lagarde. I'll just point out that the standard order that I enter in every one of these tax appeal cases is to require that the parties mediate the case and that they have mediation on or before. This particular order in this case requires mediation on or before July the 10th, date of July the 14th. I don't know if that's something that y'all can schedule that soon, but obviously I agree with your assessment, Mr. Lagarde. It's always good for the parties to sit down and discuss. I'm not sure why it hasn't happened before now.
Honestly, there hasn't been any communications with Mrs. Baker. Again, like I said, it was with arbitration. Yeah, that kind of just sidestepped me right there. But I can reach out to her for sure to schedule the arbitration. There will at least be an attempt to schedule it. I'm not sure it'll be scheduled before July 14th, mainly because the ADR needs at least 10 business days out. But I will, if I have Mrs. Baker's email correct, which I have it as kindafbaker@gmail.com. Okay.
Yes, that's correct.
Thank you. Thank you, Mr. Lagarde. I appreciate that. Ms. Baker, what are your thoughts regarding it? And understand now is not the time for y'all to be talking about the substance of the case. Mostly we're just trying to figure out what the procedural posture of it is.
I'm open for mediation.
Okay. Okay.
I'll send her an email out today, asking her what day she's available and what dates we have. More than likely, Your Honor, it's probably not going to get scheduled until August. Mainly because of the dates that the ADR office has available. And I think we've already taken up like 3 of the dates already. I can try, but just an FYI, it probably won't get scheduled to early August.
Okay. And I understand that, Mr. Lagarde. But just so you know, these come, in my experience, we get these in batches, and as I'm sure that you do, that, the vast majority of these cases completely resolve long before they ever get to me. But it is my standard practice to enter an order for mediation and a notice of pretrial conference. And just so you know, this petition was filed in February and my order was entered in May. So,
We'll get on it for sure, Your Honor, to say the least. Notice
of my order. And so I don't want to jeopardize the possibility that the parties can resolve the case. These are cases that should be resolved. But generally speaking, it should have happened long before now. And so, if I have to continue it, I really don't have much choice, but I'm a bit real unhappy about it.
Okay, I understand, Your Honor. Trust me, we will work on this diligently.
And Mr. Lagarde, the main issue I have is what I'll do is if you can please get something scheduled as soon as possible once the parties let me know, and to make sure that the parties have and incentive to get a date set. The case is going to remain on the calendar for trial on July the 14th. And you guys let me know, and you can just email me, that's fine. But just record and let me know that y'all have a mediation scheduled. And once I have a date certain for that mediation, then we will move the trial date to August or whatever date we have to mediation.
All right, sounds good, Your Honor. I appreciate that. Thank you.
I'm sorry, Mr. LaGuardia, I didn't mean to cut you off. What were you saying?
I was saying thank you.
Okay. Ms. Baker, does that make sense?
Yes, ma'am.
Understand what the court's doing. So likely you will not have trial on July the 14th, but I need an email from the parties letting me know that you have a mediation scheduled in order to move it. And then we have before, and you'll receive notice of that moved date. Okay. Okay. Thank you, Ms. Baker. You may be excused, and good luck with your mediation with the county. And otherwise, if it does not work out, then we will see you for trial. Okay.
Thank you.
Thank you.
Rainbow Trust versus Fulton County Board of Assessors. Austin, can you hear me?
Yes, Your Honor. Can you hear me?
Can, yes.
Okay. This is Mark Thompson for Rainbow Trust 2.
Thank you. I think when we couldn't hear you. I don't know if you were having audio issues. It seemed like you couldn't hear us before.
I evidently have a choice. It's either audio. I've got a new computer, and it's either audio or visual, one or the other.
In technology. So what I was saying to Mr. Bowman while you were trying to be able to have audio was that I was aware that the parties had said there was, this was a something of a unique issue than a standard a tax appeal case, and that the parties needed some additional time. But then Mr. Bowman indicated that he thought the parties had gotten pretty close to a resolution, but we wanted you to be able to hear before he announced what that was and what the timing was. So what is the announcement, Mr. Thompson? Do you believe that the parties are close and that, y'all will be announcing settlement here pretty soon?
Yes, Your Honor. This case involves the floating exemptions on property taxes. The assessors have sent out the 2025 assessment, which reflects the correct application of the floating homestead, basically of the homestead exemptions. And we're just trying to figure out if they're going to apply to 2024. And then there's a BOE decision that we're also trying to make sure is going to be applied. And we believe we can prepare an order that will pin this down. But I understand that Mr. Bowman is trying to get information from his clients, as I am as well, through an Open Record Act request.
Okay.
So the announcement is that we believe that we are very close to settling the matter. I think the lawyers are more in agreement than anyone, but we just need to confirm the numbers with the assessor's office.
Yeah. Well, not always, but usually the lawyers are more reasonable than their clients. The only thing I'll add to that is simply to point out the same lecture that I just gave Mr. LaGuardia, which is that this case was filed back in April, and I entered an order for mediation in May. And so, I don't enter those for fun. Like, the point is for the parties to actually go mediate the case so that hopefully they can make an announcement that indicates they've actually resolved it, even one that's more complicated than sort of a typical valuation. But all of that is mostly just me nagging. Really, the question is, this case is technically set on the calendar for, I think, July the 14th for trial. Realistically, do you think the parties will be in the position to file a notice of settlement that would get it moved from the trial calendar? Or what do the parties ideally need or want me to do? Because the last request I got was, we need 6 months of discovery. And that was part of the reason I was like, I think we need to talk to everybody and figure out what's going on. What are your thoughts, Mr. Thompson?
Yes. If I believe that, first of all, I'd like for this case to be taken off the calendar. If we're going to settle it, which I think the attorneys want to do, we may be able to do that in the next week or two. We've got holidays. We've got issues with getting people to respond to us with the county, and have to take that into consideration. But this is but if we're unable to do that, which I'm confident that we're going to be able to settle the case. But if that doesn't work, then I'll need to send discovery to the county. And just to be clear on this, the case was docketed in April. I didn't get notice of it being docketed until mid-May. And then I got online and I found the court's order and so on.
Okay.
So the county is very frankly and this is one of the problems that we're having. The Board of Assessors or the Board of Equalization or whoever it is that sends out these documents and is in control of the paperwork through the tax appeal process are not doing the best job possible, and and the lawyers are suffering from that. We're trying to work it out. But I would appreciate if we were to take this case off the calendar. I think this case is going to settle in the next 2 or 3 weeks with just work through the paperwork.
Okay. Mr. Bowman, what are your thoughts, sir?
Yeah, I'm largely in agreement with Mr. Thompson. I'm might be even a little bit more optimistic on the timeline for getting the case resolved. I would think by next week we should be able to have everything ironed out. And with respect to the timeline, as you were talking with Mr. Lagarde in the last case, I was thinking about the fact that we've seen so much of what Mr. Thompson said, some of the delays when the cases are actually being filed and getting to the court versus when the parties are receiving notices of them. As you may have seen, even in this case, there wasn't an official appearance entered in the record yet from our office, as there's been some delays in getting the actual cases even once they're filed, and that has thrown a little bit of a wrench in things like getting mediation scheduled in the time frame needed, because we're not getting the notices because we aren't entered on the case. I don't know when we got the notice in this case. I know we have a copy of it at this point. I don't know when it came in, but that's one of the issues that we have been having. But it's something we're working with the assessor's office to fix, to make sure that we have notice of these cases so that we can get them moving at an appropriate speed.
That's especially problematic given that this is like the easiest case ever to make sure that the interested, I mean, other cases, lawyers are be here, the party who's complaining, right, who has gone through the appellate process, we already know who they are. And certainly we know that the Fulton County Attorney's Office or some particular attorneys at the Fulton County Attorney's Office are going to be handling any of this matter. So it seems like an easy problem to address, but a problem nonetheless, Mr. Bowman.
I couldn't agree more, Your Honor.
So here's what my question is. I don't mind giving you a little bit more time. It doesn't seem like it may be that you will have an announcement for me in terms of a notice of resolution by July the 14th, which is when this case is set for trial. But I don't want to be unrealistic. And so do you want me to look at putting this matter of Mr. Thompson's request was just to take it off the calendar entirely. I don't typically do that, if only because I find that when they get taken off the calendar entirely, 6 months later, we're all like, wait, what happened to that case? And so what I would likely do is just move it to that next trial calendar, which would be in August. And then by that point, if the parties have resolved it, they can let me know. If the parties haven't resolved it, that would give Mr. Thompson a little bit of time to try and engage in some discovery or open records practice if he needs to, especially given it seems like good faith belief that it is a matter of timing, but that it's going to result in a resolution. I'm trying to think I'm looking at my calendar. I believe it's the week of August the 25th. That would be but it might be the week of August the 18th. I can't swear to that right now. But that would be what I would do is just move it to whatever trial date would be in the next month of August. What are your thoughts on that, Mr. Thompson?
That's an improvement from where we are, but and I'll just add that I'll be pushing the case because I'd like to get paid, and so I have an incentive to move the case. So I assure you, I will not be resting I'll be trying to move it.
Okay, I don't doubt that, Mr. Thompson. Mr. Bowman, any concerns about that, sir?
No, Your Honor, that sounds good to us as well.
And that is what we will do. We will reset it to the August trial calendar and hopefully look for a notice of settlement at some point. And just so you know, that is my preferred, if y'all do resolve the case before it's set on the trial calendar, and especially with these cases, sometimes there's paperwork that has to be done before it can actually be dismissed. So if you just file a notice of settlement, we will put a hold on the case until the parties have all the paperwork in order and are ready to actually file the dismissal. So if y'all need to do that, take that route, but we will issue a new notice for a trial date in August. I do not expect that I will call you back in for another pretrial conference. It will just be a notice of a trial date. Okay?
Very good. Thank you, Your Honor.
For me, Mr.
Thank you.
Thompson.
Nothing more from me, Your Honor.
That's all from me. My audio is a little sketchy.
Yep, but we're hearing you just fine. So y'all take care and have a good 4th of July.
Thank you, Judge.
Okay, thank you. Thank you, Your Honor.
Thank you. And Mr. Jackson on the Daphne. Where are we on the possibility of settlement? Have we mediated? What are we doing with that, Mr. Jackson?
No, ma'am, we haven't mediated yet. I'm happy to talk to Mr. Lagarde about the matter and see if we can resolve it. If we can't, then mediation's fine, Your Honor, and then put us on a trial calendar.
Okay, so insert my earlier,
Judge, if you don't mind, let me interject over there. So I reached out to Mr. Jackson at least 4 times, one of which I included the mediation order and asked for dates that he was available, and I never heard back. So that's pretty much why we have not scheduled mediation prior to today's date.
Okay, well, as I was going to say, insert my prior, you've heard my lecture twice now, Mr. Jackson. There's no need for me to repeat it. But nonetheless, it is my preference that the parties, and it's not just my preference, I ordered it, that the parties mediate the case, and they've not done so. So I feel like this will be the same situation that you heard me outline a moment ago for Ms. Jackson, which is the case is going to remain on the July 14th trial calendar until the parties notify me that they've agreed on a mediation date. And then if mediation is successful, great. If it's not successful, and Mr. Jackson, you feel like you need to engage in some additional practice before the case will be ready for trial, you can let me know at that time. But right now, case stays on.
Your Honor, I've got a leave. I don't have a leave-in. I'm a practicing attorney. I haven't appeared before you before, but I've got a specially set wrongful death case on the 4th of August. I've got depositions next week in a fatal collision case, a UGA football player that was killed. On the 14th of July, I'm scheduled for a 4-day vacation in Maine. I do not have a leave-in, Your Honor. I'm happy to get with Mr. Lagarde, Your Honor. But as it relates to these 2 properties, my office is on Edgewood Avenue, Your Honor, up near the Thumbs Up. You may be familiar. The property that's next door to me is a old church, and then there's some property next to it that I bought. One of them is a property that I paid $5,000 for from the city of Atlanta. 2 years after I bought it, the value of this property is suddenly $100,000 plus.
Let me interrupt you, and I apologize for cutting you off because I'm certain that you have lots of persuasive arguments that you could make about why y'all are in this dispute.
Yes, Your Honor. If I might ask the indulgence of the court.
Hang on.
You're muted, Your Honor. I can't hear you.
I'm talking into the microphone. I understand my box is muted, but I'm talking into the courtroom podium.
Yeah, I couldn't hear you, ma'am.
Okay. Can you hear me now?
Yes, ma'am.
Okay. So, as I said, I'm certain that you have lots of that you could present to me regarding the dispute that is at the heart of this matter, but that's not really the issue. Again, I don't mind continuing this case from the July 14th calendar. My requirement for doing it, though, is that y'all agree on a mediation date. Now, that mediation date doesn't have to be before July 14th, but your agreement to mediate and notify me that the parties have a set date to mediate this matter is what I require to move the case from the July calendar.
Yes, ma'am.
What I was outlining is y'all get together, agree on a date that you will mediate the case. Email me before July 14th and tell me we've agreed to mediate this case on whatever date that is. And then I will remove the case from the July 14th trial calendar and place it on a calendar at some point after your mediation date.
Yes, ma'am.
And if y'all are not able to resolve it and you feel like you need additional time to prepare to litigate the case, to actually try it, then you can tell me at that point.
Yes, ma'am. I think that can be easily done. And Mr. Lagarde, you may have emailed me, sir, and I don't doubt that you did. I've either overlooked them or they're still unopened in my email, and I apologize for that.
No worries.
Well, we're in contact now, and that's what matters. And so I will look for an email from the parties in the next, basically this next week is when I'll be expecting an email from you, letting me know that y'all have agreed on a date certain for mediation. And once I get that, I will move the case from its current trial setting to another trial setting that is after the mediation date. But it's not going to, I mean, like, I would suggest against coming back to me and saying, we've agreed to mediate the case in October. I'm not going to be real happy with that if that's what we do. So, okay.
No worries, Your Honor. I appreciate your indulgence.
Okay. Thank you very much for your time. Y'all are both excused. I hope you have a great weekend.
Thank you,
too,
ma'am.
Charlie.
Okay. Weissman and Mr. Bradley. Sorry to make you hang around for so long for that. But I mean, really this case, as I'm disappointed that Ms. Brown, I mean, I'm not necessarily surprised, but I am disappointed that Ms. Brown did not appear, simply because in writing, at least, she continues to represent that she wishes to somehow be involved in the case, even though she is in default, which seems to be a source of confusion for Ms. Brown because there is not a default judgment, but the court has entered an order of default. But in any event, I guess, tell me what is the party's current posture in terms of discovery and where the parties believe the case is, because the only real holdup in terms of is y'all's ongoing. I mean, the only reason I haven't entered an order of default is, as I mentioned with another case on the calendar today, my understanding is that the proof of damages is going to be, even though this is a loan with some liquidated, items, that ultimately, the proof of damages is going to be a little more complicated than just entering a default judgment as to the Tiffany Brown defendants, which is why I've held off on doing so, subject to having it all at one time as part of any trial that the parties engage in. I'm sorry that my audio seems to be a struggle for people today. Are y'all able to hear me okay?
For the most part, yes, you are.
Sorry. Ask IT to work on that. In any event, where are y'all procedurally in this case?
Your Honor, we have depositions that we're supposed to go ahead next week. One's in Alabama, one's in Florida. I talked with the opponents. I agreed to push them off. So we have 2 depositions set for this month. We have 1 deposition that's going to be in Florida, and that's actually, I was glad you called this conference because I just wanted to raise a quick issue with that he is only available the day after, or that we're both available the day after discovery closes. And I had agreed with Matt, plaintiff's counsel, that we would be allowed to take that deposition, even though it would be outside the end of discovery, and that if there were some issue with a motion to compel on the documents that he was subpoenaed to bring, that I would still be allowed to bring that motion. And with the court's indulgence on that, I would appreciate it, just so we can avoid any kind of procedural issue with that. There's probably maybe 1 or 2 other depositions that I'm going to notice. Plaintiff has served discovery on us, and we're going to be responding to that. But Your Honor, I should have just put that at the beginning. last time I looked at the criminal docket for Miss Brown, she had to report to prison by June 20th. So I don't think, and again, Your Honor, this is, take this as hearsay or take this as speculation, but I mean, that was kind of my understanding. So I'm not terribly surprised she's not here. And I don't know how, if that is the case, that she had to report to prison, how she would participate. I mean, she's been on the certificates of services and she came to one deposition and left about 20 minutes into it.
Okay.
So I think this is kind of, I don't want to disparage her because she's not here, but this is kind of her MO, to say that, I'm not getting a fair shake, but, every opportunity has been there for her to participate, but.
Well, I feel like I've given many opportunities for her to participate and that she has accused herself of that by filing things. And, my issue is simply one of if she seems to, at least her filings indicate, wanted to participate in discovery. And my goal had been, because again, I have zero insight other than sort of the anecdotal items that y'all will tell me from time to time. I have zero insight into what is going on. I simply know that there was a criminal prosecution that tangentially is associated with the underlying litigation funding that's in dispute here. I don't know anything about the substance of it, or certainly didn't know that she had been convicted or pleaded guilty or had reported to jail. In any event, we will move ahead. To that end, Mr. Bradley, regarding Mr. Weissman's outline. So while you were speaking, I was able to pull up the amended scheduling order that's currently in effect, which I entered on the 20th of February. It's got a discovery end date of August the 12th. And then dispositive motions in September, a mediation deadline, which I will underline and that I've had to do earlier today. And I understand, given the posture of the case, it may be that mediation is difficult or likely to be unsuccessful in many cases. But, if the parties are able to accomplish it, I would appreciate it. And then it would be, right now, you're looking at a trial date in December. So do the parties feel like you need me to actually move something, or do you feel like you're moving along and can live with that August 12th date with that one accommodation that Mr. Weissman mentioned?
Your Honor, I do anticipate some issue with some of these depositions. One is of an FBI agent, which I'm trying to get authorization to go ahead. I think I'm going to have problems with a couple of these documents for these depositions, and one's in Alabama, one's in Florida. I do anticipate it. I would appreciate the court's indulgence. I mean, we are moving this, and just to push it a little bit. I mean, I anticipate filing a motion for at least partial summary judgment as well. So I don't know if the trial date would if that would kind of run into each other on that issue. So, Mr. Bradley, I know you probably want to take my client's deposition again, which was, I guess, suspended based on the privilege issue that had come up. So, I mean, there is a bunch to do. I mean, things are definitely on the calendar. Things are moving ahead, and we have things planned. Like, we're not sitting, but I do anticipate some issues coming up. And I will say this, Your Honor, Mr. Bradley and I have had informal discussions about resolving the case. It's certainly a possibility. I'll be candid with you. I've got an eroding policy that's eroding.
To do.
Yeah.
Mr. Bradley, what are your thoughts on that? And do you think that, so what are your thoughts on what Mr. Weissman said? And do you think that the parties need to think about moving some of the deadlines? I mean, you're only, I can't believe I'm going to say this, but you're only on your first amended scheduling order. Means you haven't run out of justifications for why you need additional time. And Mr. Weissman's point is well taken. It seems like the parties aren't actually engaging in active litigation. Oftentimes, what I'm stuck with is nobody's done anything. And now they're like, can we have more time to do some stuff that we didn't do before? That doesn't seem to be the case with y'all. What are your thoughts on that, Mr. Bradley?
Yeah, I don't disagree with much of what he said. I don't mind doing things a little outside of the order. like he had mentioned. Um, but I don't know what it's like to schedule an FBI agent's deposition. Um, so I mean, if there are problems and we need to push things off, I'm not super opposed to it. I'm really kind of hoping to get the go ahead to ask for what's left on the policy and call it a day with Mr. Wiesman's clients, but that's where I am with it.
Fair enough. And I apologize. Am I mispronouncing your name, sir? I called you Mr. Weisman. Is it Mr. Weisman?
It's Weisman, Your Honor, but trust me, you're definitely not the first and you will not be the last. So don't, that's okay.
So here's my thinking. I mean, obviously it sounds like the parties are working well together. I just want to point out that if the parties feel like, another few months of discovery would benefit the case or would benefit the ability of the parties to resolve the case, then feel free to submit a proposed amended scheduling order that extends those deadlines, and I will happily agree to it if the parties are consenting to it, because as I said, it's clear that y'all are trying to get the case moved forward and doing the litigation of the case. So that's fine with me.
I appreciate Your Honor, and just for Mr. Bradley's, just information, the less depositions we do, the less erosion occurs. So this is the way it goes with that. So I appreciate that, Your Honor.
Excellent. Well, that's all I need from you all. What I am going to do is I'm going to rule on the pending motion. I just have the one pending motion that Ms. Brown filed. The response has been filed by the plaintiff. I'm intending to rule on it. And then other than that, I will look for a proposed amended scheduling order if the parties agree that one is necessary. And I will not see you guys again unless there's a discovery issue you need to address or unless we get to the dispositive motions deadline. Okay?
Excellent. Thank you, Judge, and have a great weekend.
Have a good holiday.
Thank you, Your Honor.
Thank you.
For those of you here for the 10 o'clock, we're not just ready to start that 10 o'clock yet. It's a little bit ahead. And so I'll be back with you in just about 5 or 10 minutes. So thank you. One of y'all mute the podium, please. No, like on the computer, mute the Zoom.
Judge, if you could just say something, okay, assuming you said something, I was, oh, here you
Hey,
go.
Mitch,
Yes.
I was talking and you couldn't hear me.
Okay, fantastic.
Okay, can everyone hear me? Mr. Knighton and Ms. Culver, are y'all both here?
Yes, I'm here.
Okay, Ms. Culver, are you here? Okay.
I'm here. I was muted.
Oh, okay. No, thank you, Ms. Culver. So if the two of you could please turn your video on. I know I know that we are doing this by video, but you are still technically participating in a court proceeding. I see Ms. Culver, thank you, and Mr. Knighton. You're on, please. Okay. So we are here today in a motion for temporary restraining order that was filed by Mr. Knighton against Ms. Culver. Mr. Knighton has filed a lawsuit against Ms. Culver, alleging defamation, specifically alleging that Ms. Culver has made false and defamatory statements about Mr. Knighton online, including on social media and in public forums, which he alleges those statements are false and have resulted in damages that he has alleged. Now, I have received an email from Mr. Knighton. Ms. Culver, have you received an email with documentation that Mr. Knighton intends to show the court today?
No.
Okay. Mr. Knighton, have you had the ability, I mean, don't get me wrong, most of what he's presenting, I in my brief glance through it, are communications by you, allegedly, so you would be able to know if they were yours or not. But let me outline for y'all what we are doing today and what we are not doing today, right? So Mr. Knighton actually filed this as a motion for ex parte, right, relief, right, which means he was asking for a temporary restraining order without notice to you, which legally he's allowed to do. But as a policy here in Fulton County, what we do is we say, look, if I do that, I'm just going to have this hearing all over again with both of you here. So why don't you just make every effort to notify the defendant against whom you are seeking the temporary restraining order. And that way we can have a hearing where both parties are here. And that's what has occurred now. So as outlined correctly in Mr. Knighton's motion for a temporary restraining order, Mr. Knighton would need to be able to demonstrate today that he would suffer immediate irreparable harm if I don't grant him a temporary restraining order. That the temporary restraining order is the harm that would result in not granting the temporary restraining order, in granting it is less than it would be if I didn't grant it, and that it is in the public interest, and that Mr. Knighton would like rights of his defamation claim. So both of you are pro se, which means you don't have lawyers, and so I want to let you know a couple of things. I cannot give you legal advice. I cannot counsel you on what the causes of action are. All I can tell you is if there's evidence that's admissible, not admissible, that sort of thing. But I do want to say that it is important that we proceed in sort of an orderly fashion, which is that I'm going to let Mr. Knighton have a few moments to outline for me what his position is. And then I'll hear from Ms. Culver to have a few moments to outline for me what her response is. And then Mr. Knighton will be given an opportunity to present whatever evidence he believes he can present to support why he believes he is entitled to a motion for temporary restraining order. One thing I do want to start with, as I'm in a moment, Mr. Knighton, I'm going to call on you, is to let you know that my review of the documents that you have sent is that there are sort of two things happening here. One of them is, I think I am inferring, Mr. Knighton, and you can correct me if I'm wrong, that the first set sent me were your phone records. And I understood from that you're going to be inferring that there's some ongoing harassment or continued contact. The reason I mention that is because that's not one of your causes of action, and that's actually procedurally not even appropriately in front of me. if you are alleging harassment and want a temporary protective order from someone to stop what you allege is harassment, that's a different thing. What we're doing here today is your allegation that you've been defamed and that allegedly posts that are ongoing, still out there in the social media sphere, are continuing to damage you. And I understood your request to be a request that I temporarily order that they be taken down to maintain the status quo unless and until the parties fully litigate the case. So that's what I understand us to be here about and what I understand us to not be here about. Mr. Knighton, it is 10:20. I'm going to give you like 3 minutes-ish just to very briefly outline for me what you believe the crux of your case is and specifically the nature of the relief that you are asking me for. And then Ms. Culver, I'll be calling on you for the same thing. Okay?
Okay.
All right, thank you, Your Honor. The call logs were just to show that I have not made contact and this continued harassment is not provoked or agitated by me, and it's escalating on its own out of my control. I've only monitored the statements because I've been receiving a lot of death threats, a lot of hate, a lot of just a lot of irreparable harm to my my business. My business is Allen on Sachs. I'm an entertainer and public figure, and that's very important. That's how I make my income. That's my primary source of income. And I believe that these attacks are intended to prevent me from being able to work and defame my character as my primary source of income, and my business relies on public relations. Most of my clientele are women. And so I have endorsement deals that I've been, the social media slander has sent them messages, personal messages, in regards to these allegations that have not been filed in court that allegedly happened in January of 2024. So the motive is clear that this is a revenge and defamation in order to harm me and such. I don't believe that financial compensation will repair this damage that's done, because once the reputation is defamed, most of my clientele are women, and so it would make it uncomfortable. And so without legal litigation, I think these actions show gross negligence in doing so without filing police report and doing things the legal way. This was a way for Miss Ashley to damage my reputation and cause me harm. It's very mentally taxing on me, as I do have a daughter and I'm self-employed and entrepreneur, to maneuver throughout the city as I do public events, and I've received thousands of death threats. I can't tell who it's from or where it's coming from. Miss Ashley Culver has made over 40, 60 videos in reference to my name, using my name, Allen Knighton, my brand, Allen on Sachs, and referring to me and my likeliness ongoing. She's also been able to monetize this defamation on TikTok in order for her own profit and gain. So it's ongoing. The motive is clear, and I've been used as a muse to weaponize, I guess our interactions, also for for harm to myself and for financial profit and notoriety for herself. Furthermore, this has even came to my business page on Google Maps, where I get my reviews. I've had negative reviews of 1 stars on my things, comments, justice for Ashley, justice for Ashley. Some of the reviews cannot be taken down because they didn't leave a comment. However, Google will take down some of the ones with the 1 star and a comment and things of that nature. So these things, it's clear through the documentation that these things are irreparable, and financial compensation won't fix the harm done to my reputation. I would like the court to grant the temporary restraining order so that we can handle this legally, and I won't be in the court of public opinion, because that's something I just can't fight. And it's really mentally taxing, because as I'm trying to move forward and handle things as I'm supposed to, I'm disabled from doing that, because every time I post something from my business, I'm getting attacked. I have daily, even today, very hateful comments like die, N-word, explicitive, and things like that. Because every time she mentions my name or the videos that she already has posted with my name, which have 2.1 million views, I've received about an influx of 256,000 of her followers coming to my page, trying to destroy my brand, my ability to work, and things of that nature. So that, without me, I'm taking the 3 minutes, that pretty much sums up my position. And I didn't want to do it without notice because I didn't want this to further escalate because, that's used as fuel to, continue to perpetuate this online narrative that everybody's hooked into and that I'm being attacked from daily. It's sped over now from TikTok to Instagram to Facebook. My family members have been getting notices, comments. They have threatened my mother, and she lives, by herself. And so there's a lot of danger involved that is not justice. It feels more like a revenge and slander. And so that's the position.
Understood. Thank you, Mr. Ms. Culver?
Thank you, Your Honor. Thank you for allowing me to speak. I'm here today because I spoke publicly about my experience as a survivor of sexual assault and narcissistic abuse, which occurred on January 24, 2024. I reported this incident to the police, and I have a formal investigation now, and I've cooperated fully and submitted all available evidence, including a video of the night of the incident that happened, therapy records, and a recorded conversation with my therapist where the accused was present and did not any of the allegations. I chose to speak about my experience online, not to harm anyone, but to heal and to connect with others who have suffered in silence and to raise awareness. I am a survivor, not a harasser. Everything that I've shared publicly has been based on my personal experience, and I've tried to handle this process with truth and integrity. After legal actions were filed against me, I've experienced from what I believe to be an act of intimidation. On June 28th at approximately 3 a.m., someone knocked on my window while I was on live TikTok speaking with other survivors. I cannot confirm whether it was a plaintiff, but given the time of the court filings and the live discussion of the abuse, it left me to feel unsafe and targeted. I reported this and submitted it as a part of the evidence to the court. This pattern of behavior, accusing me of defamation, filing for an emergency protective order, and potentially showing up at my home, feels like an attempt to silence me for speaking the truth. I am asking the court to recognize the distinction between harassment and a survivor telling her story. Truth is not defamation and advocacy is not harassment. I have reported this to the police. I have video evidence of the night in question that I'm speaking about, where Alan Knightson sexually assaulted me. I did not consent to sex, and he had sex with me anyway. We talked about this situation in therapy in front of our therapist, and I actually have a recording of the therapist giving his professional opinion on Mr. Knightson's reaction when I brought that up. I wrote a letter for my therapy records to read out loud in front of Mr. Knightson and Mr. Warren Mitchell, where I discussed the abuse. And Mr. Knightson attempted to give me some type of remorse, but could not take full accountability for his actions. And the therapist has also said that he believes that Mr. Knightson was not in a place where he was able to feel like he should take accountability for it, because he believes that he might have been afraid that he was going to get in trouble. Everything that I have said was the absolute truth. I never lied on Mr. Knightson about sexually assaulting me, because it's very true.
Okay, thank you. Ms. Culver. Okay, so I have an idea of what the parties are disputing. Let me, in a moment, I'm going to call on Mr. Knighton if you want whatever evidence it is that you would like to present to the court. It doesn't, it is a little bit informal when we are this preliminary stage. And so that can either be, you telling me, you providing me with documentation, et cetera. I know I've got your records, but Ms. Culver would need to see them. I do want to go back to something I said a moment ago, though, which is that you have alleged defamation. And certainly Your position, Mr. Knighton, is that the allegation that Ms. Culver has made, which I understand is an allegation of sexual assault that occurred in January of 2024, is a false allegation, and that has defamed you. I understand that to be your position. But the resulting issues that you are complaining, those might be evidence of your damages, right? If you were successful in proving that that was a false allegation. To the extent that you're asking me to order people to stop harassing you that are not Ms. Culver, I want to be clear that I don't have that authority, right? I only have authority over Ms. Culver if I were to grant any such relief. And if to the extent that you are alleging that Ms. Culver's actions are harassing you, separate and apart from an allegation of defamation, then again, that's not really my purview. That is a temporary protective order that is handled by a different court and has different standards. And so I just want to be clear that I really want us to focus. Now, some of the contact you're alleging you've had, Mr. Knighton, certainly would be relevant for the court to consider the possibility of irreparable harm, the likelihood of success on the merits. Those are all relevant things. But I just want to be clear that any order that I might be inclined to enter when this hearing is over, if I do, is not going to go really to that issue. So do you understand that, Mr. Knighton?
I do, and I understand the complexities of the issue, being that the messages of death threats are not from Ms. Culver. However, the incentive or the field to the flyer is coming from her post and using my name and such like that. So she's kind of like the ringleader to this online cyberbullying.
Okay.
And I believe in this new world where, with the internet and social media, cyberbullying is kind of like a new realm, and I would need legal help in the court to put forth a motion to Ms. Culver to at least not use my name, because she is when she does that, she is basically weaponizing that social media, which is causing the cause and effect. That is irreparable because of the bad reviews that can't be taken down, because of the loss of jobs. I've have a really big corporate clients that have been very stagnant in hiring me, which caused loss of income because of the posts that actually Culver is making and allegations that she is making online, that's creating this flood of kind of like cyberbullying that is in numbers that are unfathomable, and consistency that's unfathomable, directly tied to her ongoing posts. And so I will hope that the court, through the evidence I have presented, will see that because of the posts that she's making, the statements that she made using my name and likeliness, that she is responsible for that irreparable harm. And that's why I need the actions of the court for the motion to throw in order to alleviate that, because financial compensation for the defamation case will not repair the reputational harm that's being done.
Okay. So Mr. Knighton, this would be your opportunity to present whatever evidence. I'm going to try and make this a little bit more efficient. I mean, I will tell you that I have open on my computer the 179 pages that you submitted. Ms. Culver, do you have, Mr. Knighton, when did you file this?
I filed the evidence yesterday.
Okay.
I sent a courtesy copy via email.
To the court or to Ms. Culver?
To the court.
Just so you know, when you send things to the court, you have to copy the other side, because otherwise it's considered ex parte. And so, Ms. Culver, are you in touch with my staff attorney?
No.
Okay. You received the Zoom notice though, correct, today?
Yeah.
So I think that whatever you received probably has his email address in it, but do you see his name on the screen there, Mitchell Freehoff?
Yeah. I've emailed things to him, evidence to him.
What I'm going to ask Mr. Freehoff to do is email you at whatever email address you've been communicating with Mr. Freehoff, the document that I'm referencing. Because Mr. Knighton filed it, but it hasn't been uploaded into our docketing system yet. And when he sent it to the court, he didn't send it to you. So I want to make sure you have access to it and are able to open it. Are you able to access your email while you're on this hearing?
Yes.
Okay. The reason I ask, I'm going to take a brief break. Mr. Freehoff, do you have an email from Ms. Culver?
Yes, Judge, I have received an email from her.
Okay, thank you. Will you please forward her the same thing you just forwarded me, which I think was entitled Plaintiff Exhibit Evidence?
Yes, I'll do that now.
I'm going to take a few moments to let you get that, so that you'll be having access to the same information that the court has. I do want Mr. Knighton just to sort of, as I said, to be a little bit more efficient. I appreciate the phone logs, but am I correct that the primary original issue is page 19 of your PDF, is a Facebook post that Ms. Culver made? I don't know that I'm technologically savvy enough to say what day it was made, but that it seems to be a screenshot of an alleged Facebook post that Ms. Culver made, alleging a sexual assault on January the 26th, 2024. And that is the original posting that sort of began this. Is that correct, Mr. Knighton?
Yes, there's a that posting on around page 93. There's a TikTok video as well, and the TikTok is what is gone viral, and as well as the Facebook as well.
Okay.
But so it's both of those platforms. I don't know what her Instagram platform, but all her social media platforms of this statement has been made.
What is the date of the Facebook post, and what is the date of the TikTok post?
Okay, 1 second, please. The date of the TikTok post is 6/12/2025.
The date of the TikTok post?
Correct.
And what about the date of the Facebook post?
1 second, I'll check on that now.
Thank you, sir.
I don't know the exact date, but I have it marked on my screenshot as June 12th as well.
Okay.
June 12th, 2025.
Okay. Just to sort of aid my understanding, Ms. Culver, I'm assuming there's no dispute that you've made these posts and that you've made that allegation, correct? That the dispute, it seems to me here, is that Mr. Knighton says that that's not true and you say that it is. Is that roughly true, Ms. Culver? And also, you're muted.
Yes, absolutely. That is true.
And are the dates that Mr. Knighton is alleging for the original posts roughly accurate, that they were earlier in mid-June? He said he thought the TikTok was June the 12th of 2025 and that the Facebook post might have been around the same time.
It was right around the same time. I made the Facebook post first and then I made the TikTok post, and everything that I said in the Facebook post is true. And I have evidence to prove that we have talked to our therapist, and I wrote a letter to the therapist where we sat in therapy together to talk about, the sexual assault that happened, and I have evidence of the therapist and I talking amongst each other. And I asked him what did he think, what was his professional opinion of what Mr. Knighton, what was his reaction in in therapy when I brought the situation up.
Okay, understood. Thank you, Ms. Culver. Mr. Knighton, yeah. Well, hang on. Ms. Culver, have you received that email yet?
1 second.
Okay. I'm going to take about a 5-minute break to let you have an opportunity to get that and just maybe look through it a little bit.
Okay.
Mr. Knighton, when we return, I'm going to be calling on you to sort of present whatever evidence you think is necessary for the court to understand. I will be looking for, you can walk me through the documents that you've submitted. You can, summarize it. You can do whatever you wish, but it's 10:40. We're going to take a break until 10:45. So hopefully Ms. Colville will have an opportunity to receive those documents, and then just glance at them quickly. And then I'll come back and be looking at you for whatever presentation you're going to make. Okay, Mr. Knighton?
I completely understand. I do have one question. I know that she's able to receive my documents. Is there a way I can recover hers?
Well, I don't know that she hasn't filed any or given any to the court.
Okay, understood.
The only reason that I'm making sure she has these is that you actually filed those, and so I need to make sure she has them. Now, if she chooses to present, and Ms. Culver, I'm hoping you can hear me, if she chooses to present documents or anything like that here in court, she's allowed to do that because this is a very rapid response. But I don't have any, if I have anything that was from Ms. Culver, I would make sure that you had it, but I don't have anything yet.
Okay, understood. Thank you.
So we're on break until about 10:45.
Okay.
Will y'all mute that, please? Thank you, Mr. Knighton. Ms. Culver?
Yes, I'm present.
Okay, Ms. Culver, are you there?
I'm here.
Thank you. Have you had an opportunity to receive those documents?
Yes, I have had the opportunity to receive the documents.
Okay, thank you. Mr. Knighton, also in response to your last question before we took a break, Mr. Freehoff, my staff attorney, let me know that Ms. Culver had submitted a few documents, I think late last night or early this morning that I was not aware of and had not seen. But since they were provided by Ms. Culver, he did forward them to me, and I believe he indicated he forwarded them to you as well, so that you would have the benefit of what she had submitted to the court. I don't believe they've been filed; they were just emailed to the court.
Understood.
Mr. Knighton, if you would like to go ahead with your presentation.
All right. So my presentation, I'm gonna go. There's a lot of evidence. There's about 100 pages of it. But before I get started, I want to address to the court that this incident happened in January 2024. We most recently broke up about probably 4 months ago when we saw each other, incentivized by Ashley, and were intimate until about 4 weeks ago, where we were intimate and I had no further contact with her, and then she blocked me. And I'm going to show you some text that will outline the sense of retaliation, even the fact of the matter that that's why I asked for the court documents. The police report that she filed was only in retaliation. And I feel like I hope that the court is able to see that this is a bad retaliation that she used to weaponize even the court system in order to protect herself. And I feel like she trying to misuse the legal filing of harassment to cover her own liability in the matter. Also, there's evidence of foreseeable harm, although Ashley Culver is not doing this harassing per se over and over. She is the fuel to the flame, and there's foreseeable harm. So in the documentation, let's see, the evidence on, 1 second. On around about page 76, there's a text thread from me and Ashley. Let me find the exact page. Oh, page 122. There's a text thread with the header says Ashley, and I think in the text said, what time? I definitely thought you would call back, but I guess I was not important. That's around June 1st was the last time I've seen her. I think around that time, I know for a fact no police filings were filed, or I think the action for social media posting and start. That's also marks the day when we also stopped communication to show the motive is more so based in retaliation and revenge than it is justice. Also, I on page 76, I asked Miss Ashley after she texted me, I don't know the date, she unblocked me and texted me unprovoked because I had stopped communication. And when she did do that, I asked her to please stop contacting me. I am formally asking you to cease all communication by phone, text, email, or social media. This request is being documented. Any further contact may be considered harassment and handled accordingly. I wish you peace, but I'm moving forward. If we move to a couple of pages down on that same thread, you'll see that she copies and pastes.
Sorry, Mr. Knighton, there's an issue with my audio. It's not your fault.
Okay, sorry.
Stop you because I was trying to ask you a question.
Oh, I apologize.
Okay, you've referenced page 76, and to make sure that I understand what I'm looking at, right? So that is a screenshot, it appears to be, of text communications between two people. And at the top of that screenshot is a little, thumbnail photograph of a person identified as Ashley. And so I understand you to be representing to me that this is a screenshot from your phone of communications that you had with Ms. Culver. Is that correct?
Correct. Just to paint the timeline.
Okay. And the text messages in blue on the right are you, and the text messages in gray on the left are her. Is that correct?
Yes, that's yes.
Thank you. Go ahead.
I was saying that after I asked for cease communication, she then replied, copy and paste the same thing, and then further stated that my smear campaign against her will not work. But I have not publicly said anything about her and things of that nature. So that was a little bit confusing. But the point more so is more retaliation. I'm handling this legally. She says the same thing back to show the kind of reactive nature to it, and also to point out the point that we've had healthy communication until the breakup, and when the breakup happened, then all this other stuff escalated. I think it's at a sense of control, but also on around page 112, I have the communications because of things that actually done with a DJ that I'm working with. We had a dealing with a corporate partner. She's been receiving messages on her page, incentivized by Ashley's post, and that message, it was conflicting to my business dealings as well. Second, on page 158, you'll see a post by Ashley Cover that probably happened between the dates of June, between June 1st when we stopped talking to June 12th, where you can see that the caption reads, "The best way to get over a man, get a richer one." And that's where she started her kind of like, breakup post type thing, which shows escalation already started, and I didn't respond to it, which led to more things and such. Also on page 157, you can't see the video, but if you watch the video, the title says, "When you discard a narc, get ready for a smear campaign." And I'm not too hip about this whole narcissistic ideology and this online campaign against it. But in this video, she kind of outlines the behavior of what somebody would do in order to smear campaign to somebody, which feels like that's what's kind of happening, and how this relationship is being used to weaponize against me and cause irreparable harm to my business in order to damage my reputation out of retaliation. One second. On page 118, you'll see a video, a direct message from Manstone Saxophones, which is a company that I'm endorsed with a message that shows Ashley in the video crying. And they say some concerning information has been shared in public platforms to make your company aware that one of the artists you sponsored, Alan Sachs, currently has a rape and assault allegation against him. There's also video footage of him not emotionally and verbally showing abusive behavior towards a former partner of his. I will provide a link, but for warning, this video and the following are explicit and may be hard to watch. I'm sure your business nor your affiliate teams were not aware of this before the individual, and it does not stand for anything your business promotes. Thank you for your day. So that message, so easy to make different TikTok accounts. I don't know where this is coming from or who does that, but that seems very thought out and I don't know the right word, very thought out and planned, and the malicious behavior. And this is a new company, and I have posts that has these people tagged. So not only are they sending me messages, but they're going to my contacts, the people who are responding to my comments, they're going to my endorsers. They're doing everything without proper channels of court and legal action being proven to keep me from working and to have the success and to grow as a citizen, as an individual. I don't think that's fair or just, and that's why I really need the help of the court to step forward to repair this irreparable harm and do this thing through legal proceedings. Now, also these text threads, the text thread earlier will show that we had good communication to a breakup. And I don't know where the police report has filed, but I think it was, okay. My batteries are going dead. Let me plug up real quick. Sorry.
Okay.
I think the, one second so I can focus. Excuse me.
That's okay.
Oh, so I was saying, I'm not sure when the police report was filed, but I do believe from my own assumptions that the police report was filed after the social media posts were made and after my legal proceedings were made. And that also shows how she used the legal system to weaponize and to cover up her protection, you know, and also, yeah, weaponize her protection. Sorry, that phone thing distracted me with going dead. I lost where I was, and I need to get my phone. 1 second. Sorry. As a retaliation, and excuse me, and it's really I pose no direct threat to her or anything like that. So this has been kind of like a back and forth. And back to the documentation. So without me kind of reviewing, you know, every single page, because it's 100 pages, that's pretty much my position. And if you scroll through all the documentation, you can see that her posts, which contain about 60 videos, and when she goes live, the reference and the likeliness to me has fueled that. And so in closing, I would like to point out that bad faith retaliation courts frown upon, well, bad faith retaliation, abuse of process, and the lack of credibility. Being that we were in good communications until the breakup, and that everything started after that. And then that the financial compensation is will not fix the irreparable harm done from her actions. And that's really the biggest reason why I need the court's assistance in filing this temporary restraining order.
Okay. Thank you. Ms. Cooper, I'm sorry.
Yes. I would like to know a few things that are that I hear that are error. I've never harassed Mr. Knighton ever. And when I did reach out to him, I reached out to him because it was provoked. He reached out, which is in his evidence. He reached out to a friend of mine and told her about all the things that people were saying on social media, which made me reach out to him and tell him that I'm not defaming his character. It's in the evidence. I'm not defaming his character because it's true. And I said I have evidence, like from from our therapy sessions, and I have evidence from I have the letter in my phone that I wrote and read out loud to the therapist on April 1st, 2025, the exact same day that we had our therapy session on April 1st, 2025. Now, I did not, after he reached out to my friend on June 15th, the next day is the day that I went to the police to tell the police what happened, and I filed their police report. He filed his after mine. He had no idea that I went and already filed it. And honestly, even in the Facebook post that I posted, I said that I didn't want to criminalize him. Actually, I can, well, I don't want to read it, but in the end, I said I never wanted to criminalize him for this because all I really wanted from Mr. Knighton was a genuine, sincere apology. And because he did not take accountability for his actions, that led me to believe that he is possibly able to do this to somebody else. So with that being said, I've never harassed him, and I would love to be able to play the conversation between the therapist and I to prove that everything that I said in that when I made the initial Facebook post was true. I would like to play the video where Mr. Knighton was verbally harassing me, and he says we're not gonna have no sex. I'm about to roast it. Well, okay, what he said, I'm quoting what he said verbatim in the video, and you could clearly hear me mumble. You could see in the video that I was intoxicated. I was missing an eyelash. My hair was a mess. And I literally said in the video that I did not want to do it. And I went to the police and told them what my story was that day. And what led to the events of, that happening. Like I said, it's in the police report, and the police and the detective has reached out to Mr. Knighton, and he fails to cooperate with the police to prove his innocence. I'm not sure why that is, but I have taken legal actions against this because I realize that this is a serious case. And if I want justice, this is the way that I'm going to have to get it. It's not retaliatory. I believe that he's saying that I'm doing this because of the relationship ended. I'm not doing this because the relationship ended. I'm doing this because he's not taking accountability for his actions. And I believe that the law can hold him accountable. So with that being said, I have not harassed him. And in the communication that he's saying, where he said, please don't contact me. And I responded and I copied and pasted back to what he said. He continued to message me back and forth. He continued to message me. So it was not harassment. And you can even clearly see that in the evidence that he sent. So it was not harassment, because even days later, he called my phone to say, hey, I'm about to go to the court. Let's handle this, a different way or whatever. So it wasn't harassment. And Alan Knighton and I were in therapy for quite some time because our relationship was very toxic. I do believe that Alan Knighton has very heavy narcissistic tendencies, which made our relationship very difficult to navigate. And it's very hard for me to even bring up the abuse that happened. I never felt like I could, because when the incident happened, I was the one that was blamed for what happened. So I didn't want to talk about it. And I never felt like I had a safe place too. So on record, I have in a therapy, the first time that I had ever brought this up was in a therapy session, because I felt safe enough to be able to discuss what happened in front of a third party, where Mr. Knighton had to take accountability for his actions and what he had done. And I really want to play the video so you can see what happened. And I really would love to play the audio of.
Sorry, I'm sorry to interrupt you, but I wanted to interrupt you on the specific issue of this therapy session that you have referenced a few times. I'm not going to let you play that video. And the reason I'm not going to let you play that video is the limited understanding I have of what it is and why it exists is that you and Mr. Knighton were seeing a therapist for purposes of working on your relationship.
Yes.
And it likely means that any of those statements, well, generally statements by Mr. Knighton would be admissible, that those statements likely are privileged because they were made for purposes of, therapy, treatment, etc. And so those would likely be that anything like that would likely be privileged under Georgia law. And so I'm not saying that it might never come in if there's some later litigation that we're dealing with, further down the road. But for purposes of today, based on what I know about it, I think it's best that we don't go down that road because I'm concerned that it is privileged. And I also, I want to ask you to focus on one piece of this for me, because here's the thing. We are at such a preliminary stage that your assertion that this is true and happened, right? And Mr. Knighton's assertion that it is not true and did not happen, I'm never going to be able to resolve that issue today because I simply don't have enough information at this preliminary stage to make any such assessment. What I am concerned about is Mr. Knighton, and this is what I wanted to focus your response on, if you could, for a moment, is you said I didn't harass Mr. Knighton. And in terms of your characterization at this preliminary stage of the text chain that I've seen, right, you're probably right. That's just communication between you and Mr. Knighton. But what I understand his real complaint to be is that your posting of this matter, and perhaps posting more than once in more than one location, has resulted in, or I'm characterizing Mr. Knighton's argument, it has caused people to harass him at your direction or as a result of your actions. And Mr. Knighton, if I'm understanding your argument incorrectly, you can tell me in a moment. But I wanted to ask you about that, Ms. Culver, because in terms of the limited communication I've seen between the two of you, you're probably right that doesn't rise to the level of harassment. But I think what Mr. Knighton is talking about is that the continued posting of it and engagement with others online about it have resulted in lots of people getting involved and resulted in the harassment of Mr. Knighton. as a result of what you've done, not necessarily because you are personally harassing Mr. Knight.
Yes, I 100% understand. And I've only made 2 posts about with his specific name in the on my TikTok, and I made a post on Facebook, you know, with his name. And truth is an absolute defense to defamation.
That is absolutely correct, Ms. Knight, Ms. Culver. I'm sorry. That is absolutely correct. That ultimately, right, in the actual litigation of this case, if you were to prove that this occurred, right, then that would be an absolute defense of his claim of defamation. You're absolutely right legally, but we are at a preliminary stage now. And so I appreciate your response regarding the harassment issue. And I interrupted you only because I wanted to make sure that you were clear that I was not going to allow you to play the video. And really, you really should refrain from characterizing the content of it as well, because based on essentially the preliminary information I have about it, that information is likely privileged. And so not only would you not see the video being admissible, it's that, you know, we can't really talk about those statements because those statements were made in a private therapeutic setting. But besides that, if you have other evidence you want to talk about and reference, please continue, Ms. Culver.
Yes, I would like to talk about the video of the night in question before everything, the night that the sexual assault happened. I would really like to play that video for you when Mr. Knighton snatched my phone out of my hand to record me in a completely disoriented state, you know, as he pretty much said exactly what he was going to do to me before he did it. So I would really like to play that video because that's the video that's causing people to say things to Mr. Knighton, because people can clearly see in that video that I was in no condition to have any sexual interaction with him that night. Am I allowed to play that?
How long is the video?
1 minute and 29 seconds.
Okay, Mr. Knighton, what are your objection thoughts about whether or not the court should hear that video or observe that video?
I have an objection to that because I think it doesn't align with the focus of the case. The focus of the case is that her videos, such as that one, and the use of my name and likeliness of my name, and her several other videos, are causing harassment. And this matter should be handled in court, not in public litigation, because this video and exposing things like that just shows gross negligence and irreparable harm. I do not give her consent to use my name and likeliness for her own financial gain, which is happening on TikTok, and notoriety and growth, and nor do I wish my personal information to be public. I wasn't, honestly, I was here to focus on the defamation and death threats and the mental harm that's been done to me, and creating 2 victims if her alleged allegations out of 1. I think without her filing the fact that the police charges or whatever, allegations and charges were not filed until after the posts were made. She said that she filed the police report on June 15th. She made the post on June 12th. So she made those statements, and that just shows gross negligence. So I think whatever evidence about that case is irrelevant to the defamation and irreparable harm that's being done in public opinion and not handled the legal way. And that's why I need the protection and help from the court.
Okay. Thank you, Mr. Knighton. So a couple of things. One, Mr. Knighton, your objection, I understand your objection. I will say, though, that, one of the elements of a temporary restraining order is a demonstration that you're likely to succeed on the merits, right? And so one way that someone can demonstrate that a party is not entitled to a temporary injunction is by demonstrating that you're not likely to succeed. In other words, by demonstrating that this actually occurred, and so therefore it is not likely to be able to prove that it didn't occur. Now, having said that, Ms. Culver, I think for purposes of today's hearing that I can accept your characterization of what it would show if you showed it to me, and that I don't necessarily need to view the video at this point. Other than that video, accepting your representation of what it would show for purposes of the hearing today, that you were intoxicated and in physically demonstrated in the video that you were not, interested in or willing to participate in sexual relations, right? So I'm going to accept your characterization of that. Anything else that you would like to make argument about or direct the court's attention to in response to Mr. Knighton's motion?
Yes, I honestly believe that Mr. Knighton is doing a strategic lawsuit against public participation. I generally believe that because I went to the police and let them know what happened, and the fact that he's not cooperating with the police, if he's saying that what I'm saying is a lie, why won't he go to the police to talk to them, to let them know that this did or did not happen, while I have all of this evidence to prove that it did? And the fact that he's running away from speaking to the police, to me, is very telling. And he showed, I believe, that when I was on TikTok live on June 28th, last Saturday, he came to my home to harass me. And I feel like, with given the timeline of everything that's happening, and given the timeline of the emergency meeting that we're having here today, directly after someone came to my home and knocked on my window at around 2:50 in the morning, I have a video recording of the audio of that night when someone came, and there were others on live with me. So I do believe I do believe that Mr. Knighton is trying to sue me here today, or trying to go through with this lawsuit, because he's I believe that he's guilty of what I said that he's guilty of, and I 100% believe that I'm the one that is being harassed by him.
Okay, I understand. Thank you. Anything else, Ms. Culver?
No.
Okay. Mr. Knighton, it is your motion. And so generally my practice is to let the party who's moving have the last word. And so you can respond to anything that Ms. Culver has said, or make any argument that you would like to make. Now will be your opportunity to do that. Go ahead.
Absolutely. And first, in regards to the police report, because I honestly prefer to handle this legally, as I also have evidence myself. I had no contact with the police department until this week. I don't know the exact date. Oh, June 1st, where the Douglasville County Sheriff's Office came to my house. I was not home. He left a number. I called him immediately, met up with him, and got the documentation. That's the first contact I had with police. Other than that, I have no idea what Ashley's position is on this case. I know from a social media post that she was talking to her followers, and they were asking, why have you done something legally around that June 12th? And from my knowledge, she hasn't done anything yet. From the police report, I did see that she accused me of showing up to her house June 28th. I was working that day in Alabama, and I went to sleep early, and I was out of town because I was working. And I also have my ADT records to show when I was home, and also motion around the house, as well as text threads when I left a friend's house. And when I got home, I left my friend's house at a particular time and got home 15 minutes after, and it shows I'm home. I text my mother I was home, and it also shows the ADT records of me being in the house in motion in the basement. So that those accusations, I'm just got found out aware about it, but I do have many receipts myself. And if the allegations from the video and perceived of my character, I didn't submit the audio evidence because I just did pictures, because I haven't learned how to do the audio and video evidence submission yet. So I have to do some more research on that. I do have audio evidence that shows a pattern in our relationship of makeup sex that shows us having a debate. And then I accidentally left my phone on just because I started towards the end of the relationship. I didn't, the arguments were always escalating as I was trying to de-escalate. So I started recording the arguments just for my own safety to review, to see, what's going on, what's causing all this turmoil. And then I left it on. And then it's about, I think I have 2 videos, maybe 3, of us engaging in a debate. We saying, I hate you back, and then engaging in an intimate affair. And then I start snoring, and we wake up. Furthermore, in regards to the therapy session and the alleged allegations, I wasn't aware of this rape theory or her feeling that she was raped until our therapy session on April 1st. This was not made aware. I didn't know that her experience, that she felt that way. And around April 1st, 2025 is kind of where the relationship wasn't getting better, and a lot of just imbalances were happening. We're not talking about violence and things like that. We're talking about common relationship woes of just accountability, emotional availability, and things of that nature. So I don't really believe that her evidence of me being avoidant or using the court as a weapon are valid or true, being the timeline and series of events. What I do believe is true that although she's not directly sending me the messages, she is aware of the irreparable harm that can be done to my business and to my name and to my brand and to my mental health through her continued videos and slander. And not only that, although she stated that she only used my name in 2 videos, there's 2 videos, the one that I'm in cussing, and I did have a human experience, I do admit that. And then the other video when she explains the sexual assault video. And then the likeliness and references to me, my ex. I'm the only ex, and she has videos posted me on her page. People can easily scroll down and say, oh, she's talking about that guy. As a somebody who's in the public eye and things of that nature, this damage is irreparable, and I would need the court for the temporary restraining order so this can be handled legally. And I think the evidence in the timeline will also show that the times of the posts and things like that. No, I'm still using it. Excuse me. The times of the times of the posts and things like that show kind of a backwards way of handling legal issues and the lack of immediate danger to herself. And I do, if you want to see, I do have easily viewable the ADT records, the text threads to show that my character is of one that's focused and moving forward and taking accountability of the things I've done wrong, but also have to protect myself from how easily it is to weaponize a little bit of truth with a couple of lies. But the defamation and irreparable harm is horrible. And not only that, but TikTok, they have found certain comments in violation, but they don't find everything in violation. So it makes it difficult for me to do my business, to move forward, and the things of that nature with this ongoing slander and constant video making, which is using the likeliness of our relationship to continue the perpetuation of this slander.
Mr. Knighton. So I cannot tell you how sad I am that the parties are where they are in this matter. Primarily because it is unfortunate that Ms. Culver has had the experience that she has had. It is unfortunate that Ms. Culver's posts have resulted in what I expect likely is harassment, because sort of social media takes on its own life, and that can be true even if I fully credit what Ms. Culver alleges happened. Right, that doesn't change what could be perceived as harassment of Mr. Knighton by complete strangers, posting things on Mr. Knighton's business page and things like that. Having said that, although, here is the problem that the court has in terms of the relief that you are seeking, Mr. Knighton. So Ms. Culver a moment ago said something very important, which is that she believes this is an anti-SLAPP suit. And I'm certain that she didn't call it that, but she read out the abbreviation, which is the strategic litigation against public involvement. But anyway, what an anti-SLAPP statute is basically a lawsuit that tries to make someone stop saying things that are a matter of public interest. And she is alleging that that's what this is. Now, I've not been asked to rule on that. I don't know if the elements of an anti-SLAPP statute are present, or an anti-SLAPP lawsuit are present here in terms of whether or not you could prevail on the merits of your case. I will say this. The primary issue for the court, though, the primary issue, though, for the court, Mr. Knighton, is that unfortunately, the case law is pretty clear that that parties have a right to free speech, and that I'm trying to pull up the case that I want to actually cite to you, so that you'll know what I'm relying on. There's a case called Brown versus MBC Partners. The citation for that case is 246 Georgia App 549.
Sorry.
What?
No, excuse me. I'll get it from the transcript. I'm sorry.
Okay. I'm happy to tell you again, the case citation is Bryan, Bryan, versus M as in Mary, B as in boy, C as in cat Partners. And the citation for that case online is 246 GA period APP period. I call it Georgia App 549. It is a 2000 case out of the Court of Appeals. It is representative of any number of other cases. But the primary issue is, hang on, I want to read you the language. Generally, an injunction will not be granted to restrain the tort of slander or libel, which we in modern terms refer to as defamation, however illegal and outrageous the communications may be. And the reason that I read that case law to you, and you'll find lots of cases citing it, is that in the absence of a contract, for example, a non-disparagement agreement or a restrictive covenant agreement that says you can't say certain things or you can't post certain things, the law is pretty clear that Ms. Culver has the right, from the matter of free speech, to continue to say the things that she is saying. That's number one. Number two, Mr. Knighton, is that it seems as if the real issue that you are struggling with is that Ms. Culver's posts have resulted in others sort of glomming on to that and engaging in something that seems harassment adjacent. The problem is those parties aren't in front of me, and I don't have any authority to make them stop. And as I said a moment ago, because Ms. Culver is legally allowed to make those statements as an exercise of her right to free speech, it would be a prior restraint, and I think improper for me to order her not to say anything else, and improper for me to order her to take down those posts, which are likely what is causing others to see those posts and then engage in harassment. Now, because of that, Mr. Knighton, unfortunately, I don't believe that I am legally authorized under the elements of a temporary restraining order. I believe that because of the First Amendment interests at stake and because of the anti-SLAPP issues, that the court, that it does not serve the public interest for the court to enter the restraining order that you have requested, even though on its face, I don't disagree with you that you are likely experiencing irreparable harm, and that the harm you are experiencing may be outweighed in terms of those elements that the court would typically apply. But I don't know if you can succeed on the merits of your claim, but even if I were persuaded that you could, the primary issue to me are two things. One is this issue of the court not being authorized to police people's free speech as a legal matter. And number two, I think there's a question as to whether you have an adequate remedy at law. And what I mean by that is that because of concerns about allowing people to make, to say what they wish, right, to engage in protected free speech, generally speaking, the remedy for defamation is damages, money damages for that result from the alleged defamation. And when generally, I understand the law to say that when there is an adequate remedy at law, in other words, there's a way for you to get legal relief, you don't necessarily also get equitable relief in the form of ordering someone to not do something or do something. And so for those reasons, I don't think that you would likely be entitled to a temporary restraining order in this case. So I'm going to have to deny the application that you've made. there are a couple things I do want to make sure that the parties are aware of. Number one, and this is for your benefit, Ms. Culver, by telling you what I'm about to say, I am expressing no opinion, right? Because I don't have any hard evidence in front of me and we are very preliminary. But we want to make it clear that the remedy for alleged defamation that Mr. Knighton is asserting is damages. And so even though the court cannot, I believe, legally order you to stop making posts and making these statements online about what you allege occurred, right? And what you allege Mr. Knighton did, I do want to make sure you're aware that if you continue to post them and Mr. Knighton were successful in demonstrating that it was false, those additional posts would be evidence of his damages, right? So, and again, I'm not giving you legal advice. I'm not telling you that you can't post them. I'm just saying you should, I want to make sure that you are aware of that. Do you understand that, Ms. Culver?
Yes.
Okay. Now, the second thing I will point out, and I just want to make sure procedurally where we are in the case, is that Mr. Knighton has filed a lawsuit that alleges a cause of action for defamation. Ms. Culver was, according to my file, it looks like she was served with that lawsuit on June the 26th. So she has time under the law to figure out how she wants to respond to that complaint. Now, once that happens, then I'm going to enter a scheduling order that allows the parties to engage in discovery, and then y'all can do what you need to do in terms of attempting to get, evidentiary documentation of the parties' respective positions. I will tell you that the existence of the criminal cases are likely things that would not be relevant in the civil case. I'm not prejudging anything. I will deal with it when anybody tries to present it to me. I do think that y'all should be aware that those things are typically separate. It may be that the parties need to figure out what's happening with any criminal prosecutions that are occurring or criminal investigations that are occurring before they figure out how they want to proceed. Because I think I understood that both parties have filed some sort of police report regarding the other's actions. And so I just want to make sure y'all are aware that those things, the existence of them may play into the ability of this case to move forward long term. The substance of them likely would not, if that makes any sense. In other words, any finding like a decline to prosecute or a decision to prosecute and a subsequent conviction might not necessarily control the outcome of any civil lawsuit. Does that make sense, Mr. Knighton?
Yeah.
Ms. Culver?
Yes.
Okay.
Well, I do have a little confusion.
Well, okay, go ahead.
My confusion lies in what you said earlier about the freedom of speech and issues like that. I'm just I don't know, having a human moment because like the death threats and all that, like where's my protection, And I just don't understand how it's so obvious that Ms. Culver is putting fuel to this and is causing the reaction of that, where I don't feel safe to maneuver around. I just have a hard time processing. No, it's cool. It's just I don't see how that's just, and I just don't see it. I just don't. And it's outlined in the evidence, but I think I'll just end up, lawyer. Cause I don't feel protected, and that's why I came here for.
And I'm very sorry, Mr. Knighton. As I said, I'm not making any assessments about what happened here. But I don't accept that not necessarily Ms. Culver's communications with you, but that the online reaction to those posts is very concerning and is difficult for you to deal with. I don't question that at all. The issue, though, is several things that I've outlined, which is number one, the people that are actually engaging in what probably is, harassment and is scary, et cetera, are not people that are in front of the court. And so I have no authority to order their statements to be taken down or to order, any online forum to remove those posts as it stands currently. And the primary issue with Ms. Culver's statements is that she does have a First Amendment right to make those statements. And the remedy, if those statements in fact are false, is for you to demonstrate. No.
Did he leave?
I don't know. He was having some issues with his phone, so it may be that his phone died. We were basically almost done, Ms. Culver, but what I'm going to do is take about a 5-minute break and see if Mr. Knighton jumps back on. If he doesn't, then I'm going to assume that he's not been able to remedy whatever technical issue he has. But if you'll just pause for a moment, I'm going to take about a 5-minute break and see if he's able to jump back on, okay?
Okay.
Thank you. Let me unmute that.
Hello. Sorry.
No, okay. We took a break since you had fallen off, and you mentioned something about having to plug in, and I figured you just were having technical difficulties. So we just took a break when we lost you until I was taking a break for 5 minutes, but it was only about a minute or two.
Apologies. That's exactly what happened.
Okay. Well, as I was saying, I understand that you are frustrated by the outcome, Mr. Knighton, but as I said, I think that ultimately, legally, I don't believe that I am allowed to order Ms. Culver to take those statements down, because Ms. Culver has a right to make those statements, and the remedy for you, if those statements are false, is to file a lawsuit like what you have filed to say she is defaming me and I have been damaged as a result, and here's evidence of my damages. Unfortunately, I don't believe that the law allows me to order Ms. Culver to stop saying what she is saying, except just to advise, to make sure she understands legally that if she continues to say those things and it is proven, I don't know if it would be, but if it is proven that those statements were false, that could be evidence of damages or evidence of continued publication of the alleged defamatory statement. So in any event, that's where we are leaving it. Mr. Knighton, I'm going to enter an order that denies the request for a temporary restraining order. Again, based on number one, I believe that you have an adequate remedy at law, which is an action for damages, which you are pursuing. And also that I believe that from a legal perspective, that the court is not authorized to enter an order restraining Ms. Culver from making those statements in the context of libel and slander, defamation. And so as a result of that, that's going to be the basis for my denial. But again, the next thing that I will do is wait for Ms. Culver to respond to the complaint. And once she does, then I will enter an order requiring parties to engage in whatever discovery, and the case will proceed along in an orderly fashion, assuming that it is continued to be pursued. Any questions for me before we adjourn? Mr. Knighton?
No, I do not.
Okay. Ms. Culver?
No, I don't have any questions.
Okay. Well, I appreciate your time, and I wish you both the best to hopefully resolve this and move forward more positively. But otherwise, the case is on the calendar and we will proceed according to proper procedure. You will receive notice of any additional proceedings that we have, and I will bid you good day. I hope you have a good weekend and a good holiday. And I will enter an order. Y'all have, it'll probably be on file next week sometime. Okay.
Thank you.
Thank you all. Have a good day.